England, in September 1670, was a nation with a fair few skeletons to shake off. London stood as the largest city in Britain, and the third largest in the Western world, behind Istanbul, then known as Constantinople, and Paris, with a population estimated between 350,000 and 400,000. In Cambridge, Isaac Newton had been appointed Lucasian Professor of Mathematics at the age of 26, just a year earlier. Whilst he was no doubt a megamind, a great teacher he was not. This meant his lectures were largely unattended, giving him time to work on experiments in calculus and optics, whilst progressing his theory of gravitation. There was no United Kingdom until the Acts of Union in 1707. Rather, the Kingdom of England, which included Wales, and the Kingdom of Scotland, were united only by the Crown, the so-called Mary Monarch, Charles II, who sat atop multiple kingdoms, glittering in the success of the Restoration, having ousted Cromwell's Puritan, theatre-hating Commonwealth just 10 years earlier. 1670 was a tenuous yet hopeful time. For those of you still besotted by your school history classes, you will note it was just 4 years after the Great Fire of London had destroyed 13,200 homes. Alongside St. Paul's Cathedral, around 100,000 Londoners were made homeless, and nearly 80% of the city of London was reduced to ash. Only a year before that, the Great Plague had claimed the lives of a quarter of the city's population in just 18 months, scarring the capital and shaking public faith in both government and divine favour. London was rebuilding, not only in stone, but in spirit. Yet, despite the return of the monarchy and theatre, control and conformity ruled with an iron fist. The judiciary still danced to the tune of authority, eagerly enforcing the Conventicle Act of 1670, which criminalised religious gatherings of more than 5 people outside the official church, the Church of England. Whilst Charles II's return in 1660 had occasioned the release of some 700 Quakers from prison, their initial relief was sadly, as with many instances in the 17th century, short-lived. Dissenters, such as Quakers and Baptists, were mercilessly pursued, facing harsh penalties under the Act. However, in a courtroom at the Old Bailey, a legendary jury was about to defy not only the judge, but the very structure of power itself. Indeed, a 26-year-old Quaker, rebel, and the future founder of Pennsylvania, William Penn, stood alongside his friend Captain William Meade on trial for unlawful assembly in a legendary matter that would later become known as Bushel's case. Thursday, August 14th, 1670. Penn and his fellow Quakers were forcefully ejected from their meeting house on Gracechurch Street in London by constables. The cunning constables took up posts around the house to ensure the meeting remained outside. Penn, undeterred, took off his hat and began to preach to a large crowd estimated at 300 to 400 by Constable James Cook. One of the Quakers, John Rouse, clearly felt disrespected by such a guest, estimating the assembly himself at several thousand. Richard Reed was one of the unfortunate watchmen tasked with trying to grab Penn. However, this attempt to apprehend Penn faced a fair share of difficulty, as the crowd were relentlessly kicking him and his watchmen on their shins. By preventing the officers from doing their duty, the actions of the mob were interpreted as not merely rout, but as a much more serious offence of a riot. Although the officers couldn't arrest Penn and Meade with the mob locked onto their shins, Captain Meade, full of confidence, approached Constable Cook and told him that if the officers had the decency to wait, he and Penn would surrender themselves when they had finished speaking, an early form of what would now be considered riz. Once the rabble had died down, the constables later arrested both men after the two gentlemen had got what they needed to say off their chest. Unfortunately, by this point, Penn and Meade had not only become liable to prosecution for preaching to a conventicle, an offence which carried a £20 fine, roughly £4,000 in today's money, but were also charged with rout and riot, a much more serious transgression. As Newgate Prison was too crowded, Penn and Meade found themselves in the Black Dog Inn, near Newgate, awaiting trial. I'd like to hope with a healthy supply of beer and ale for their troubles, as mead had become a bit expensive by the 1600s due to the cost and availability of honey. A fortnight later, on Thursday, September 1st, 1670, Penn and Captain Meade were placed in the dock at the Old Bailey. The trial was presided over by Sir Samuel Starling, the Lord Mayor of London, and Sir Thomas Howell, Recorder of London, two gentlemen that could adequately be described as big fish within the judiciary. They were joined by 5 older men and 3 sheriffs for the initial hearing. Unsurprisingly, in introducing the case, Sir Starling defended the government's position and also defended the actions of the judiciary. However, things took a more unusual turn when he started insulting William Penn's father, ridiculing him for the handling of the Navy during the Anglo-Dutch Wars. Starling was clearly trying to get under Penn's skin with a tactic no member of the current judiciary would consider proper, an indirect ad hominem attack, criticizing the character of Penn's father rather than the substance of the case itself. Never the man to back down, Penn energetically defended his father, Admiral Sir William Penn, who sadly passed away just 15 days later after a distinguished naval career, no doubt with his son's trial and tribulations on the back of his mind, and without the slightest idea his last name would soon be immortalized as the 5th most populous US state. Whilst it was meant to be a straightforward prosecution under the newly renewed Conventicle Act, Penn had other ideas. He argued that if he pled guilty, the act would acquire additional force. However, if he denied his guilt and threw the burden of proof on the court, he would show to all the world the evil animus of his persecutors, raising the question of whether this new and oppressive law was in harmony with Magna Carta. Magna Carta was a foundational document signed by King John in 1215, which, amongst other things, established individual freedoms and made clear that everyone, including the king, was subject to the law. As such, Penn and Mead, still blazing with confidence, and having been denied a copy of their indictment, entered pleas of not guilty and decided to try the case themselves without the benefit of counsel. A decision that many current lawyers would probably cringe at, but as previously noted, Riz. Court was then adjourned until Saturday the 3rd of September 1670. As researchers Phillips and Thompson noted, nothing in this first meeting foreshadowed the struggle to come. The whirlwind weekend began with Penn and Mead approaching the bar with their hats on, another move that wouldn't help too much nowadays. Quakers, however, rejected the practice of removing their hat out of respect and deference to judges of royalty, as they believed God alone was worthy of honor and reverence. Thus, they refused to show hat honor to any human being, no matter how powerful. Suffice to say, Sir Starling wasn't too impressed, instructing a bailiff to remove their hats, whilst fining Penn and Mead 40 marks each for contempt of court, with each mark being worth 2/3 of a pound. This equated to roughly £10,000 in today's money. Of course, I've run the numbers so you don't have to, and at an average price of 4 shillings back in 1670, Penn and Mead could have bought 266 quality wool felt hats for the cost of wearing just 2 in court. The jury, the other superstars of this trial, and those I'd like to immortalize as a famous 12, consisted of, drumroll please, Thomas Vere, Edward Bushel, John Hammond, Charles Milson, Gregory Walker, John Brightman, William Plumstead, Henry Henley, Thomas Damask, Henry Mitchell, William Lever, and John Bailey. Some cracking names if I do say so myself. In hindsight, I'm sure they would have wanted to settle in with biscuits and wafers at the ready, as this trial was about to bring the room to fever pitch. From the offset, Penn demanded to know the basis for the charge. Sir Thomas Howell then responded that the indictment fell under common law, not statutory law, as Penn assumed. This was quite surprising, as the Conventicle Act 1670 was a statutory offence. Given Penn and Mead were likely prepared to challenge the prosecution on statutory grounds, it seemed the judge wanted to tactically use common law as a catch-all to criminalise the disorderly conduct, rout and riot, and unlawful assembly, starving Penn and Mead of defences against the Act, and a likely demand to read the statute, which the bench would have no doubt known was unpopular by this point. This moment helped illustrate the manipulative power of the bench at the time, who attempted to blur the lines between statute and common law, alongside the legal sophistication of Penn, who had tapped into the Quaker belief that laws must be visible and accountable. Indeed, in response to the judge's insistence on common law, Penn asked for the law to be provided to him, slyly suggesting, if it be common, it should not be so hard to produce. Penn, known as a great opinionist, continued his aggressive questioning, and it was at this stage that it seemed he was slowly winning over the jury. This frustrated Howell and Starling, who committed Penn to the bail dog. Accordingly, it was Captain Mead's turn to dial up the pressure. He insisted on defining riot under common law for the benefit of the court, citing the great English barrister and judge, Sir Edward Coke, stating a riot is when 3 or more are met together to beat a man, or to enter forcibly into another man's land, to cut down his grass, his wood, or break down his pails. Recorder Howell then took off his own hat in mock respect, concluding Mead's definition with the crucial phrase from Coke, and to do any other unlawful act. Howell then sarcastically thanked Mead for reminding him of the law, as the patience of the judges wore exceedingly thin. However, this didn't deter Captain Mead, and after the judges considered themselves insulted, Sir Starling responded that Mead deserved to have his tongue cut out for affronting the court. Unsurprisingly, Mead was then thrown into the bail dock alongside Penn. The bail dock's most important characteristic was its location inside the courtroom. However, Penn and Mead strenuously objected to their incarceration in the bail dock, as they were entitled to be present at the proceedings. It was argued that if they were in the bail dock, the jury wouldn't be able to adequately observe the demeanour of the accused, which was crucial in reaching a verdict. Sir Starling swatted away these arguments, noting the men remained in the courtroom and could be heard easily. Nevertheless, despite jurors at the time often questioning defendants, prisoners had no actual right to be present for the entire process. For example, even the specific right to hear witnesses against the accused was not granted until the reign of Victoria in the 19th century. With poor Penn and Mead locked away in the bail dock, Howell delivered his summary of the case, explaining to the jurors that they had heard proof that Penn indeed preached before a tumultuous company, and that Mead had allowed it. Whilst the judges expected a guilty verdict, they did seem sufficiently uneasy about the jurors, warning them they were to keep to the facts in front of them, or face the consequences. As the jury retired, Penn and Mead were placed in the stinking hole to await their return. It should be noted that 17th century juries rarely took much time to reach a verdict. For example, the jury hearing the Penn and Mead case had already dealt with 19 other cases over the few days they were together, with the practice of one jury hearing multiple trials, only ending in the early 19th century. However, this case was different. After an unusually long delay of 1.5 hours, only a portion of the jury returned agreed, with 4 jurors remaining in the jury room, including Edward Bushel. These jurors were later berated by the judges for their behaviour. Whilst Bushel was not the foreman of the jury, he led the opposition to a guilty verdict. Remarkably, it's important to stress that none of the jurors were Quakers themselves, as a Quaker ban against oath-taking disqualified them from sitting on juries. This was simply a case of some jurors not agreeing with the law and standing up for what they thought was right. In defiance of the court, the jury refused to return a unanimous guilty verdict, despite the judge's clear direction. By this point, seriously peeved off, Howell ordered the jurors to retire again and reach a verdict. When they re-entered, Thomas Vere merely replied that Penn was guilty of speaking, refusing to add anything else. This absolutely enraged the judges, as nothing was said about Mead, and the answer from the jury didn't speak to the charges against Penn. The judges then hurled what has been quoted as the most opprobrious language at the jurors, which probably included a decent range of 17th century swear words. Some real stingers at the time included licorice glutton, meaning a greedy pig, freckled bitter, meaning a speckled or unattractive person, and ninny lobcock, dim-witted, useless oaf. Whether or not the judges used these creative terms of abuse can only be left to your imagination. Howell angrily advised the jury they had not given a verdict and had essentially said nothing. Whilst the jurors were given more time to reach a verdict, this time equipped with pen, ink and paper, their return did little to appease the judges, who simply wouldn't accept their verdict. Finally, Howell warned the jurors the law required them to be locked up overnight, without meat, drink, fire and tobacco if they didn't reach a verdict. And guess what? They didn't reach a verdict. As a consequence, the unfortunate jurors were locked up to think about their verdict very carefully, and were thus treated to one of the most demeaning forms of jury sequestration that I've had the displeasure of reading. Whilst the conditions were designed to punish and break the jurors, they were also meant to isolate them, pushing them towards a guilty verdict. In modern times, the concept of jury sequestration does have legs. It's defined as the isolation of a jury from the outside world, to prevent them being tainted, either accidentally or deliberately, by outside influences or information. Putting the urge to scroll through TikToks aside, it makes sense. We are social creatures, and we wouldn't want jurors to find themselves persuaded by journalists or friends that possess significantly less information than themselves. Sensationalism might sell newspapers, but I'm sure we can all agree it's unlikely to help jurors reach a fair outcome. Journalists rarely have the full picture, and we know they'll do anything to grab our attention, even if that means misrepresenting the facts. McDonald's coffee cup case in point. but that's a story for another time. Nowadays, most jurors are given a respectful direction to head home and avoid technology, whilst avoiding speaking about the case with those around them. How much that's adhered to is often the source of much debate, and less frequently, sanction. Of course, to those that seek justice at all costs, you might think it still makes sense to simply lock jurors up. In the US, Douglas Keene has noted that a sequestered juror is provided with no morning paper, no TV, no internet cable, and quite obviously, no Wi-Fi access in one's room. Interestingly, Mr. Keene also noted authorities take the Bible from one's bedside table. Draconian steps like these underscore the rarity of such measures. Although often requested in high-profile trials, it's rare for juries to actually be sequestered. On the extreme end, Charles Manson's jury was sequestered for 225 days. This had been the US record until the O.J. Simpson jury, wooed by accomplished trial lawyers such as Johnny Cochran and Robert Kardashian, was sequestered for 265 whole days, an insane duration with obvious consequences. Out of the original 12 jurors, only 4 made it to the end, with alternates required to shore up the numbers. As you can imagine, the chance of illness, emergencies, and misconduct only goes up the longer matters trundle on. While sequestration may ensure the best outcome, it's certainly a tough gig. In the UK, it's hard enough for the criminal justice system to get adequate funding, with the Crown Court backlog reaching a new high of 74,651 as of December 2024. That is roughly 75k serious cases remaining to be heard, perhaps partially indicating why jury sequestration is even more of a rarity than it is across the pond. For those that have watched Conclave, you may be able to see the parallels. Indeed, a conclave, from the Latin cum clave, meaning with a key, ensures cardinals are locked in to prevent external interference until they reach a decision. However, whilst the rare modern cases of jury sequestration usually result in a hotel, there were no such niceties for the poor jurors in Bushel's case. In stark contrast to modern jury sequestration, Sir Starling and Thomas Howell were likely less concerned with outside influences and more concerned with forcing a conviction. The 12 jurors were famously denied food, drink, and conveniences during their time locked away. Interestingly, these conditions remained a standard part of trial procedure until 1870, as there were no existing legal mechanisms for dealing with a hung or undecided jury. Extreme measures were meant to ensure the return of a verdict. Despite its known overcrowding, the jurors were held in Newgate, an infamous prison built in the 12th century, known for its squalor and neglect, connected to the Old Bailey by passageways, as the courtroom was built right up against the prison wall. Described as a vision of hell on earth, from 1188 to 1904, London residents lived under the intimidating presence of Newgate, a prison responsible for 700 years of despair, desperation, and death. Although Newgate Prison had been largely destroyed in the Great Fire of London just 4 years earlier, and had not been formally rebuilt by Sir Christopher Wren until 1672, given it was structurally linked to the Old Bailey, and has been explicitly stated in sources, it's fair to say it probably remained in use, partially rebuilt and functioning in a limited capacity. A definite downgrade from the Black Dog Inn. It was here, in those grim, makeshift conditions, that the jurors were confined, without food, drink, or basic sanitation. Indeed, the court wasn't just trying to sway them, it was trying to starve them into obedience. Given the lack of basic sanitation, and the fact prisoners at Newgate often lived with their own waste, I'm going to go out on a limb here and presume chamber pots, a type of portable toilet, were not provided. For those wondering, yes, this particular chamber pot, made in 1805, during the height of the Napoleonic Wars, features the Starboy himself front and centre. It would be another 10 years until Napoleon was finally defeated at Waterloo, so I guess Brits wanted to find ways to keep their spirits up, as the First French Empire, and Napoleon's famed ego, swelled ever larger. Now back to the Old Bailey. The jurors were brought back at 7 a.m. the next day, both an unusually early time and an unusual day for a hearing to take place. Surprisingly, the jury remained defiant. The court heard a repetition of the previous evening's verdict, including a not guilty verdict for Meade. The judges refused to accept the verdict offered by the jury, and the jury refused to render another verdict. This delighted Penn, who appealed to Magna Carta, noting that it would be reduced to a mere nose of wax if the judges succeeded in rejecting the verdict of the jury. Ignoring Penn, the judges forced the jury to retire once more, but yet again, a determined minority blocked any unanimous guilty verdict. Penn now demanded the jury be allowed to provide a verdict according to their conscience, advising the court on points of law, insulting members of the bench, and making so much noise that Starling threatened to stop his mouth and stake him to the ground. By this point, it's fair to say, Penn had driven Howell over the edge. Amidst calling Quakers a turbulent and inhumane sort of people who should not have the protection of the law, he bizarrely started talking about the Spanish Inquisition.
Till now I never understood the reason of the policy and prudence of the Spaniards in suffering the Inquisition among them, and certainly it will never be well with us till something like unto the Spanish Inquisition be in England.
Doing my best to translate the above quote into millennial English, he essentially said, the Spanish Inquisition doesn't sound too bad. At least I know I wouldn't have had to put up with this. It was a cold, cynical comment from Howell. The Inquisition was infamous for its secret trials, presumption of guilt, torture, and elimination of heresy. The fact that a senior legal officer stated the same in open court speaks to just how hostile Restoration-era judges could be towards notions of individual rights, jury independence, or fair trial. Indeed, it embodied the very tyranny that the jurors were seeking to resist. After that drop the mic moment, Howell actually left the bench, not wanting to take part anymore in the travesty he felt he was witnessing. Penn certainly didn't make it any easier for the jurors, who were once again thrown into Newgate until the following morning. After a weekend I'm sure everyone wanted to put behind them, the jury came out with their boxing gloves on. If the judges weren't going to accept their previous verdict, they were going to make sure they delivered a legally acceptable one. And so, 2 days after the trial had begun, and after 2 nights spent wallowing away in Newgate, the jury declared both Penn and Meade not guilty. Howell, fed up by this point, accepted the verdict in disgust, turning to the jury and exclaiming,
God keep my life out of your hand.
But cue the fireworks, friends, because despite Penn and Meade now thinking they were free to go, Howell had other ideas. He maintained that they were to remain imprisoned until they had paid their fines for wearing their hats at the start of the trial, a petty move, given those fines, as noted, totaled roughly 10k in today's money. Thankfully, the ailing Admiral Sir William Penn came to his son's rescue, paying both fines and freeing both men soon after the trial. But what about the poor jurors, who were undoubtedly looking forward to a well-deserved evening in the Black Dog Inn? Well, Howell wasn't finished with them either. In a final spray of bullets, he fined the jurors 40 marks each for following their own judgments and opinions, rather than the good and wholesome advice which was given to them. That is a serious amount of dough, totaling £60,800 in today's money, all for following their conscience. To make it worse, they were all sent off to Newgate until the fines were paid. Whilst judges retained their power to ask juries to reconsider verdicts any number of times for more than 2 centuries, the level of fines given to the famous 12, alongside their imprisonment, severely violated both practice and reason. Howell essentially wanted to have his cake and eat it too. He demanded the jury's reconsideration of their verdict, but then punished them for changing their minds. If every member of the jury had paid their fines happily, then this case may have just been a crazy story Penn saved for dinner with his friends. But that would have been a bit too boring. In comes Edward Bushel to the rescue. As noted, the legendary Bushel was a juror who led the defiance against Howell over the weekend. He wasn't going to give up easily, and he refused to pay the fine, believing, quite rightly, that juries should not be fined for their verdicts. After a number of weeks spent in what could now be described as his second home, Bushel came out all guns blazing and managed to have his position heard through a writ of Habeas Corpus, brought in the Court of Common Pleas. In one of my favourite books, The Rule of Law, Lord Bingham, often described as the greatest judge of his generation, believed the writ of Habeas Corpus to be the second most important historical milestone on the way to the rule of law as we know it today. In short, Habeas Corpus, Latin for "you should have the body," is a fundamental legal remedy which acts as a challenge to unlawful detention. It's even enshrined in the US Constitution. As Lord Bingham had noted, the procedure remains relatively simple. If an unfortunate person finds himself languishing away in prison, believing, for whatever reason, that he had been detained unlawfully, he can procure the issue of a writ, which commands the authorities to have him taken to a court. The prison authority, such as a governor, must then appear in court, confirm the man is in his custody, state when he was detained, and, crucially, show good legal cause for detaining him. That is exactly what the Venerable Edward Bushel did. In November 1670, after hearing the arguments in the case, Chief Justice Vaughan set aside the fines, freed Bushel, and set a precedent by prohibiting judicial fining of jurors in the future, vastly enhancing the power of English juries and establishing their right to give a verdict according to their own convictions. To commemorate such a seismic event, a plaque was created and displayed at the Central Criminal Court in London, the aforementioned Old Bailey, by Court 1, such as the enduring importance of Bushel's case that its principles, and even the plaque commemorating it, continue to be cited, including by counsel and by the Honourable Mr. Justice Saining in the recent case of HM Solicitor General versus Warner, which we'll explore later. Jury equity therefore remains a powerful way for juries to return a verdict according to their conscience. Nevertheless, it remains controversial because it openly allows juries to disapply the law, as we're about to see. George Blake lived an extraordinary life. Born George Bahar, he was the son of a Protestant Dutch mother and an Egyptian father of Sephardi Jewish origin, who was a naturalized British subject. By the time the Second World War broke out, he was living in the Netherlands. At 17, he joined the Dutch resistance as a courier. In 1942, he escaped from the Netherlands and travelled to Britain via Spain and Gibraltar. Following time in the Royal Navy, he was recruited by MI6 in 1944, who sent him to study Russian at Downing College, Cambridge. Following his studies, he was posted to the British legation in Seoul, South Korea. Undercover as a vice-consul, Blake's mission was to gather intelligence on Communist North Korea, Communist China, and the Soviet Far East. After the outbreak of the Korean War on the 25th of June 1950, Seoul was quickly captured by the advancing Korean People's Army, who took Blake as a prisoner. After seeing the bombing of North Korea, and after reading the works of Karl Marx, he became a communist. Thereafter, Blake arranged a secret meeting where he volunteered to work for the Soviet Union spy service, the MGB. Despite returning to a hero's welcome in 1953, Blake had committed to being a double agent for the Soviet Union, providing information to the KGB of British and American operations while stationed in Berlin. Over the course of 9 years, Blake was said to have betrayed details of some 40 MI6 agents to the KGB, destroying most of MI6's operations in Eastern Europe. In his own words, during a TV interview, Blake claimed to have betrayed as many as 500 British agents. Following a 3-day interrogation by MI6 in 1961, Blake admitted to switching sides voluntarily, which naturally led to prosecution. The trial was presided over by Lord Chief Justice Parker. Lord Parker's term as Lord Chief Justice was less controversial than that of his predecessor, the famous hanging judge, Justice in a Jiffy, Lord Goddard, who had presided over the trial of Christopher Craig and Derek Bentley. Derek Bentley was famously given the death penalty at 19. Bentley had shouted at Craig to let him have it after a confrontation with policeman Sergeant Fairfax, who had asked Craig for his gun. It was argued that Bentley's words had led to Craig shooting Sergeant Fairfax. What Bentley meant by let him have it has long been the source of debate. Whether Bentley meant for Craig to give the sergeant his gun, or rather shoot the sergeant, will remain unknown. Nevertheless, Bentley was hung by Albert Pierpoint on the 28th of January 1953, despite having the mental age of a child with an IQ of 77. Whilst Lord Parker was against the death penalty, which was effectively abolished in 1965, he strongly believed the citizen's highest duty was to the state. It was against this backdrop that George Blake was to feel Lord Parker's wrath. The maximum sentence for any one offence under Section 1 of the Official Secrets Act 1911 was 14 years. But Lord Parker decided his activities should be divided into 5 time periods, charged as 5 separate offences. Accordingly, he was sentenced to the maximum term of 14 years consecutively on each of 3 counts of spying for a potential enemy, and 14 years concurrently on the 2 remaining counts. This resulted in a total of 42 years imprisonment, the longest non-life sentence ever handed down by a British court. Newspapers reported that the sentence represented 1 year for each of the agents who were killed when he betrayed them, though this allegation has been questioned. Nevertheless, others have noted Lord Parker had been understandably shocked at the extent of the treachery that had sent dozens of Western agents to their deaths. Further, Lord Parker had noted that the courts have a positive responsibility to be the handmaiden of administration, rather than its government. A relatively controversial point of view, as it raises question marks over the strength of judicial independence. Following sentencing, Blake was sent to the infamous Wormwood Scrubs, a prison that continues to operate to this day. It was here that George Blake escaped 5 years into his imprisonment, with the help of 3 men, Sean Bourke, and 2 anti-nuclear campaigners, Michael Randall and Pat Pottle. Pottle and Randall's motivation for helping Blake, other than their liking of him as a person, was their belief that the 42-year sentence was inhuman. After moving Blake between their friends' houses, they smuggled Blake across the English Channel in a camper van, allowing him to eventually escape to the Soviet Union, where he lived the rest of his life until passing away at the age of 98 in 2020, buried with full military honours, with Putin, a former KGB agent himself, expressing his deep condolences. Pottle and Randall, perhaps believing the events to be firmly behind them, published a book admitting their involvement in 1989. They were subsequently arrested, and in June 1991, both men stood trial at the Old Bailey for their part in the escape, 296 months after they had helped Blake skedaddle. In keeping with the vibe of this video, both Randall and Pottle decided to defend themselves in court. Whilst they stressed they in no way condoned Blake's espionage activities for either side, they were adamant they were right to help him, as the 42-year sentence was both inhuman and hypocritical. Whilst the judge reminded the jury that neither Blake's life nor mental stability were under immediate threat, in a move that should be predictable by now, the jury acquitted them on all counts. Randall, with his own characteristic riz, later noted to journalists that there are some circumstances in which it is right to break the letter of the law, a point acknowledged by the legal defense of necessity. Not that I'd ever recommend it, but that makes it 2-0 in this video for defendants wooing juries to a not guilty verdict after representing themselves. The Falklands War was a 10-week undeclared war between Argentina and the United Kingdom in 1982. At stake were the British overseas territories of the Falklands Islands, alongside South Georgia and the South Sandwich Islands. Argentina has long considered the Falklands, known locally as Los Islas Malvinas, as their rightful territory. Thus, under the military dictatorship of Leopoldo Galtieri, it was this claim to sovereignty that led to Argentina invading and occupying the Falklands Islands on the 2nd of April, 1982. The invasion was strongly opposed by the British government, at that time led by the Right Honourable Margaret Thatcher. Baroness Thatcher had qualified as a barrister in 1953, prior to becoming Prime Minister in 1979. The Iron Lady was famously known for her uncompromising politics and leadership style, a polarising manner that led to a fair share of controversy. It took 74 days before Argentina surrendered. By this point, almost 1,000 lives had been lost, with over 2,000 wounded. Argentina suffered the brunt of casualties, with 649 killed. Sadly, 323 of these deaths were the result of the controversial sinking of the ARA General Belgrano. On April 12, 1982, the UK established a 200 nautical mile maritime exclusion zone around the Falklands Islands. Alongside this clearly defined zone, on April 23rd, the British government also sent a message to the Argentine government, stating any Argentine vessel or aircraft perceived as a threat could be engaged. On the 2nd of May, 1982, HMS Conqueror attacked and sunk the General Belgrano, using 3 Mark 8 torpedoes from a distance of approximately 1.5 kilometers. Those on the ship were reportedly unaware of the attack, and it is estimated that 272 men lost their lives due to the immediate impact of the torpedo explosion, alongside subsequent events. The sinking remains the only case of a warship being sunk in action by a nuclear submarine, and one of only 2 cases of a warship being sunk by any type of submarine since the end of the Second World War. Whilst the General Belgrano was 40 miles south of the exclusion zone, the British government asserted to the public that the Belgrano posed an imminent threat. It was under the guise of this imminent threat that the attack was justified. However, one person who this didn't sit well with was Clive Ponting. Mr. Ponting was a senior British civil servant at the Ministry of Defence at the time, and in July 1984, he sent 2 highly classified documents, subsequently nicknamed the Crown Jewels, to Labour MP Sir Thomas D.L. These documents were hugely significant, as they proved that the Belgrano was not only outside the exclusion zone at the time of its sinking, but also actively sailing away from the British fleet, contradicting official statements supporting the necessity of the attack. This disclosure to a Member of Parliament was a cunning tactic. Article 9 of the Bill of Rights, 1689, established the concept of parliamentary privilege. This means that MPs cannot be prosecuted or sued for anything said in the House of Commons. As such, once Ponting had passed the documents to Sir D.L., he was free to use them as part of parliamentary questioning without any repercussions. However, that didn't help poor Ponting, who was unceremoniously suspended without pay by the MOD and prosecuted under Section 2 of the Official Secrets Act, marking the first instance of someone being charged for leaking information to Parliament. Sir Geoffrey Bindman KC, whose firm was instructed by Ponting, has noted that all he had done was blow the whistle to an MP when ministers had concealed the truth from Parliament in clear breach of their constitutional duty. Thus, it was felt a public interest offence was clearly arguable, and the public was purposefully told Ponting's side of the story. Nevertheless, this didn't stop the prosecution, which was pushed by the unforgiving Secretary of State for Defence, Michael Heseltine. Indeed, Lord Heseltine had previously prosecuted a junior clerk in the Foreign Office, Sarah Tisdall, who had leaked to The Guardian a memorandum about the impending arrival of cruise missiles at RAF Greenham Common. Miss Tisdall was unfortunately imprisoned for 6 months due to the same. This track record had meant Ponting's prospects were looking gloomy. As such, I have to sadly announce that representing himself was no longer an option. Instead, the immensely skillful and talented Laughland QC was instructed to fight Ponting's corner. Whilst the public was fascinated by the trial, it seemed MI5 were even more so. Bizarrely, MI5 clumsily arranged for the home telephones of Ponting's lawyers to be bugged. It seemed Laughland quickly caught on to the same, as whenever the Director of Public Prosecutions called to discuss the case, he would always say,
"Good morning, and good morning to Sergeant Bloggs."
Unshaken, Laughland fiercely defended Ponting, with his characteristic lucidity, precision, and elegance. However, he was met with a huge obstacle in the form of Mr. Justice McCohen. In the jury's absence, the judge rejected the defence's submission that whether or not Ponting had acted in the interest of the state was an issue of fact for the jury. Astonishingly, his ruling meant that what was in the interest of the state was whatever the government said it was. This deflated the defense team, who then thought conviction and imprisonment seemed a foregone conclusion. Before heading into court the next morning, lawyers met Mr. Ponting for a farewell breakfast at the Savoy Hotel, who had arrived with a small suitcase containing a toothbrush, shaving kit, and other items he'd need for a stint in prison. Thankfully, that small suitcase would turn out to be unnecessary. When the jury foreman declared not guilty, there was a gasp of amazement, followed by spontaneous applause. They had ignored the judge's direction and must have genuinely thought Ponting had done the right thing. When Laughland was later made Bencher of Inner Temple in 1985, Sir Michael Havers, who was at the time of the Ponting case Attorney General, congratulated him on his victory and thanked him for being so decent about the bugging. It can certainly be argued that Ponting's whistleblowing breached his duty to the state, alongside his professional duty of confidentiality, and therefore required prosecution to stop others from getting similar ideas, preventing a slippery slope. However, it seems history has largely been on his side. The sinking of the General Belgrano remains one of the most controversial aspects of the war. Whilst the government stressed that any vessel deemed a threat could be engaged, Ponting had evidence that the Belgrano was sailing away from the British fleet. Sir D.L. suggested the sinking was carried out to undermine peace talks and bolster the Prime Minister's popularity with the British public. In May 1983, Thatcher was grilled on BBC One by Diana Gold, a geography teacher, who argued the ship posed no threat to the British fleet. In response, the Prime Minister disagreed and noted her main motivation was to protect British sailors, affirming she was very proud of her actions. The show incensed Thatcher's husband, Sir Dennis Thatcher, who alleged his wife had been stitched up by the BBC, calling them trots, a phrase used to describe those that follow the Marxist ideology of Leon Trotsky, alongside a homophobic slur which I won't repeat in this video. A subtle reminder that the BBC has had to put up with a lot over the years. One doesn't need to look far to appreciate the lasting impact of Bushel's case. Indeed, in 2023, on a rather chilly day for April, outside the Old Bailey where it all began, a number of climate activists found themselves clinging on to reprints of the famous plaque found inside its hallowed walls. They were there to support the lady front and centre, Miss Trudi Ann Warner. On March 29, 2023, Miss Warner found herself in a bit of a predicament, detained for her actions in the shadows of Inner London Crown Court. 2 days earlier, she had been there in support of a number of defendants, including her lodger Amy, who were on trial for public nuisance after a demonstration in support of the environmental campaigning group, Insulate Britain. Miss Warner felt the best course of action was to create a placard aimed at the jury so that they could absorb it before heading into their trial. The placard read,
"Jurors, you have an absolute right to acquit a defendant according to your conscience."
I'm sure these are familiar words to all of you by now. Yet, it seems His Honour Judge Silas Reed, who was in charge of the hearing that day, wasn't in the least bit impressed. Miss Warner had arguably told the truth in the wrong place. Judge Reed was sufficiently concerned to have the 68-year-old arrested and detained to the end of the day, believing her actions were contempt in the face of the court by attempting to influence the jury. He further directed the jury to ignore Miss Warner's sign, which he described as wrong about what the law is. Ironically, Miss Warner's actions were directly in response to His Honour Judge's previous rulings, where he has instructed jurors to ignore protesters' motivations, prohibiting defendants from mentioning the words climate change, the civil rights movement, or the issue of fuel poverty to the jury. It was felt that such matters were strictly irrelevant to the issues that jurors had to determine, which at times are rather straightforward questions of fact. Indeed, Judge Reed, who has had to deal with a number of climate trials over the years, perhaps felt his patience was wearing thin. As Mary Adams has noted, the UK's climate trials present a complex matrix against which the personal, political, and spiritual dimensions of British culture are being tested. For better or for worse, these trials have led to a high number of acquittals, as defendants have sought to escape punishment by appealing to the jury's emotions, justifying exactly why they have taken disruptive action, in particular due to their belief in what constitutes the greater good. Whilst his actions have been labelled draconian by some, it is important to appreciate why Judge Reed has historically taken the position he has, especially in light of the wide disruption caused by campaigners over the years. His Honour Judge believes that the desires of the defendants to speak about the motivations of their actions is that they believe that the jury will look at the case in a moral way, rather than in a legal way, a position he holds as being wholly wrong. Though other judges may take different positions, it is His Honour Judge's right to reach such a conclusion, based on his interpretation of the letter of the law. The Honourable Mr. Justice Kavanaugh takes a similar stance, describing the allegations against Miss Warner as very serious, noting that it is not the case in any trial that jurors can acquit by their conscience, if by that it is meant they can disregard evidence and directions given by the judge. To do so would be a breach of their jury oath and cause injustices. The Solicitor General then sought permission from the High Court to bring proceedings for contempt in the common law, as Miss Warner was alleged to have directly interfered with the administration of justice, deliberately targeting jurors with her sign, including in one case, hurrying to catch up with the juror to draw their attention to it. Accordingly, on April 22, 2024, the Honourable Mr. Justice Saini delivered his judgment on the matter. Mr. Justice Saini considered the tension between jury equity and the obligation of a jury to follow a judge's directions on the law and abide by their oath, an oath which is to faithfully try the defendant and deliver a true verdict according to the evidence. Crucially, Judge Saini noted it was probably best to describe jury equity as a principle of our law. It is, he said, an established feature of our constitutional landscape, one which is also recognised across the common law world. Notably, counsel for Miss Warner and for the Solicitor General both accepted that participants in the trial process cannot lawfully invite a jury to apply the principle of jury equity, or even inform them of it, striking a needed balance between jury equity and the oath that jurors are required to swear. So, did Miss Warner's conduct disclose a reasonable basis for committal? Mr. Justice Saini firmly rejected that notion. Amongst his 5 reasons, it was noted that Miss Warner did not assault, threaten, block, or hinder anyone's access to the court. Her placard did not instruct anyone, but merely shared information. Rather, Miss Warner accurately informed potential prospective jurors about one of their legal powers. She did not comment on the merits of the case, or make a claim regarding the defendant's innocence, as the common law test for contempt relied upon a serious risk of, or actual, interference with the administration of justice. It was held Miss Warner did not come close to meeting this test. Instead, all that was required was for His Honour Judge Reed to deliver a short, tailored judicial direction the day after the events, allowing risks to be addressed. And so, there was no basis to act against Miss Warner, who happily noted she could go back to her garden. Yet, the slippery slope argument with jury equity remains. Whilst my examples may teeter on admissible to the general public, some may argue the concept leaves the door open for more glaring acquittals. Others may argue that in the modern world, with modern judges, the idea of a jury of peers is not as relevant as it once was. However, it's important we don't minimize the intelligence and reason of a representative cross-section of society. We should stand back and ask ourselves, if we were to be accused of any wrongdoing, would we prefer to be judged by 12 of our peers, or instead by a case-hardened judge? It is the duty of barristers to make sure the jury understand, and it is the duty of the jury to use the law, the evidence, and their conscience to reach a decision they regard as fair and just. The avid newsreaders amongst you may have noticed that the Leveson Review was recently published by Sir Brian Leveson. It is a gargantuan piece of work, totaling 388 pages, which has sought to provide solutions to alleviate and repair our chronically underfunded and under-resourced criminal justice system. Whilst the review and its contents are not within the remit of this video, it would be remiss of me to not highlight the fact that there are now over 310,000 cases in the Magistrates' Court backlog, and, as noted, roughly 75,000 cases waiting to be dealt with in the Crown Court, where the most serious crimes are heard. At the Old Bailey, 5 of the 18 courts are not sitting. At Isleworth Crown's Court, government reductions in judicial sitting days has meant that some trials are now being listed in 2029. You heard that right, 2029. A person charged with a crime who truly believes they are not guilty could wait 4 years or longer in limbo before their day in court. Some are waiting a further 4 years on top of time already spent when their cases have to be delayed due to administrative issues. On the other side, victims must also wait an atrocious amount of time for justice to be served. The system is on its knees. However, since promises to spend more money on the judicial system don't seem to move the needle in terms of voting, justice is left abandoned. Increased spending remains unlikely to be used as a bargaining chip when it comes to elections, nor seen as a priority when other areas of funding can woo voters in. Yet, desperately needed funding isn't about putting flat-screen TVs in prison. It's about sustaining a system respected around the world. It's in this sad, precarious environment, brought on by successive government cuts, that Sir Brian's review arrives. Amongst many sensible suggestions, one recommendation painfully stands out, and that is to replace a majority of jury trials with a new Crown Court bench division, consisting of a judge and 2 magistrates. Hauntingly, the review seems to suggest we do not have a right to trial by jury, but instead merely a right to a fair trial, a suggestion I believe Lord Bingham would have strongly opposed. This new Crown Court bench division may cover 725 offences that could have previously been heard by a jury, severely harming what I would consider to be our non-codified, yet historic right to a jury trial. In a recent commentary for The Times, Mary Pryor KC noted that in 2011, the British public was surveyed about what people wanted to be guaranteed as their rights in law. The top 2 answers should be no shock to any of you: free medical care for all, and the right to jury trial. Whilst your opinions on the merits of each case may vary, I hope that if this video has left you with anything, it is that jury trials are a right we should all be immensely proud of in the UK, and a right we should fight hard to keep. As Blackstone opined 2 centuries ago, juries are the sacred bulwark of our liberties. Given the same, I sincerely hope we can all band together to ensure that right is protected for future generations. It goes without saying, if the government save a load of cash by taking it away, you can bet your bottom dollar it won't be coming back. This video is dedicated to Professor John A. Phillips. Professor Phillips was a professor of modern British history at the University of California at Riverside, as well as chair of the Law and Society program. A lifelong Anglophile, he tragically passed away in an automobile accident at the age of 48. Alongside fellow researcher Thomas C. Thompson, his determined research concerning jurors and judges in later Stuart England has been invaluable in creating this video. A link to their paper will be provided in the description.